To our webinar on Title IX tyranny. My name is Teresa Manning, the Policy Director here at the National Association of Scholars, and I'm so pleased to have with me today to discuss Title IX, the overview, and also the Biden administration's attempt to promulgate a new rule to administer Title IX, to discuss the many issues that this initiative raises. I have with me today Sarah Perry, who is with the Heritage Foundation as a senior legal counsel with the Meese Legal Center, and also Doreen Denny of Concerned Women for America, who is focused on women and children's interests and will be looking specifically at the implications for that demographic as well as gender ideology generally. The way we are going to proceed is that I am going to spend the first 5-10 minutes providing background on Title IX so that all listeners are on the same page. We are being recorded, and we welcome questions after the formal 10 to 12-minute presentations by each participant. I do prefer that questions appear in the chat. That's easier for me to navigate, so please use that function. And please feel free after the event has concluded to circulate this content to others you think may be interested. Again, my name is Teresa Manning, and I'm the Director of Policy at the National Association of Scholars. And today's topic is Title IX. So I'm going to give some history. Title IX is the 1972 federal ban on sex discrimination in federal funded education. The text is actually quite short, and I will read it so that we all have a sense of what statutory words we're looking at. It reads, "No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance." I think it's 32 words. Title IX was an outgrowth of the civil rights era and was called an equal access law, and to this day by most courts is considered equal access to education. That is the cornerstone. So the women's movement was sort of piggybacking on the civil rights movement, securing non-discrimination for Black Americans. Accordingly, at the time, it wasn't very controversial, unlike, for example, the Equal Rights Amendment, which was being discussed and advocated at the same time and was going to amend the federal constitution to mandate identical treatment for men and women. The Equal Rights Amendment was defeated, but Title IX was enacted with comfortable majorities in the United States Congress. I think, as an aside, that Title IX has become something of a beast like the ERA would have become, but we'll save that for the discussion. Early on, however, Title IX was interpreted by the Education Department's predecessor, the Health, Education, and Welfare Department, to mandate equal funding of athletics. And this was controversial. And for the first few decades of Title IX's existence, most of the court cases and discussion concerned athletics, specifically women's collegiate athletics. However, in the 1990s, with the Anita Hill accusation against Supreme Court nominee Clarence Thomas, the term sexual harassment came on the scene as she accused him of making unprofessional and sexually graphic comments when she was working for him. Now, that was the employment context, whereas Title IX is the education context. But that brings up the interplay between the other federal discrimination ban based on sex, which is Title VII, which you may have heard about, Title VII of the Civil Rights Act of 1964. That's a separate and distinct statute from Title IX. However, the courts had to decide what constituted sex discrimination, and courts would often, because this is a relatively new area, given the history of our country, it's not like constitutional rights of free speech or religious exercise. So the case law interpreting Title VII is sometimes consulted by courts interpreting Title IX and vice versa. However, this is not mandatory authority. As I said, it's just guidance. So what did the courts do early on in trying to decide what would constitute sex discrimination? Early on, quid pro quo propositions where, for example, a supervisor over an employee or a professor over a student would demand sex in exchange for a job or a promotion or grades. Early on, and even to this day, this was considered sex discrimination, and that is not controversial and uncontested. But Anita Hill had brought up something different. She had brought up comments made in the workplace, and this was more akin to the idea of a hostile environment. Hostile environment, as opposed to quid pro quo sex discrimination, is much less definable, much more nebulous. So it's not at all clear what will constitute a hostile environment. Is opening a door for someone hostile action that constitutes sex discrimination, telling a joke, or saying that you look nice. As you can see, hostile environment became an amorphous invitation for litigants to demand that certain things constitute sex discrimination, even though the supporters of Title IX may never have anticipated such uses of the statute. And then it got even worse. In the Clinton and Obama eras, the feminists who populated those administrations wanted sexual misconduct, sexual assault, and sexual violence to a form of sex discrimination banned by Title IX. This has always impressed me as a square the circle type of proposition, although we can discuss this more, because this is essentially criminal conduct that is now being characterized as a civil rights issue. So a bit of a square the circle attempt. And at the same time, as sexual hostile environment was an amorphous term being redefined, so too was sexual assault being redefined. So for example, in college conduct codes, we encounter the concept and term of affirmative consent, which demands that at every stage of physical intimacy, verbal affirmative consent is obtained, and absent that consent, you have sexual assault. So one can see that discrimination based on sex in the hands of federal bureaucrats in the now education department became one step after another of expanding the definition of discrimination based on sex to the point where we are now looking at things no one would ever have imagined. This reached its peak, I think, in 2011 and the immediate aftermath with the infamous letter issued by the Education Department known as the Dear Colleague letter, which was sent to schools to pressure them to use Title IX offices on campus to seek, find, and destroy sexual offenders as a sign of success for Title IX. That 2011 DCL lowered the burden of proof so it would be easier to find those accused of sexual misconduct, guilty of sexual misconduct. It discouraged formal hearings, including important components such as cross-examination, and was in the hands entirely of Title IX staff who are comprised mostly of feminist ideologues. And I should have mentioned that I did author a report for the National Association of Scholars on Title IX in practice on the ground, called Dear Colleague, the Weaponization of Title IX. And for those interested in seeing the documentation of this type of personnel, it is all in there in text and graphs. Unsurprisingly, the 2011 DCL resulted in what we now call campus kangaroo courts, which is to say the Title IX offices were so zealous in trying to find sexual offenders that they deemed any misunderstanding in a date to be a potential Title IX offense. They presumed guilt on the part of the student or sometimes faculty accused, and in effect railroaded many accused students and sometimes also professors. There was a pushback on this campus kangaroo court phenomenon when students began filing lawsuits claiming their rights had been violated, and often not just due process rights, but contractual rights under student conduct codes. And there are many heart-wrenching cases of wrongfully accused, wrongfully convicted, so to speak, students who were suspended or expelled based simply on an accusation, were not informed of the charges against them in any particularity, were unable to defend themselves, and then had their educational and professional trajectories completely upended. It was this backdrop that Trump's Education Secretary Betsy DeVos found upon her arrival in that position. And I think one of her most notable legacies is her willingness to tackle this mess. She rescinded the 2011 DCL and started formal proceedings to promulgate a new Title IX rule, which would make explicit and restore due process protections for those accused under Title IX, including of sexual misconduct, which I hope we can discuss in the question and answer period. Her new rule took effect in 2020, by all indications is working swimmingly. It's been upheld by every court to review it. Of course, in the interim, we've also had COVID, so it's been chaos as far as that goes. The Biden people, however, as soon as Biden came in, targeted the DeVos rule and announced its plans to promulgate its own rule to replace the DeVos rule. And that is what we are going to be discussing today. Just a few final notes. Much was made during the Clinton and Obama years that the federal bureaucrats who wanted to expand these definitions did not go through the formal rulemaking process required by the Administrative Procedure Act, which is something that DeVos did do. We can talk also about that. The Biden people now are going through that formal process again. In my view, grossly wasteful, because the DeVos effort took 3 years, reviewed over 124,000 comments, and produced a very balanced rule that has been, as I mentioned, upheld by the courts. The last thing I'll mention is that this is deja vu all over again, with the bad guys in the driver's seat, so much so that the Biden people appointed the very same Title IX czar today, Catherine Lehman, as had been in place in the in the Obama era, who is arguably the person most responsible for campus kangaroo courts and all those railroaded accused students. So I'd like to turn now to Sarah Perry so that she can describe what the Biden proposed rule does when that came out, and where we are now, and what provisions, in her opinion, are most objectionable to get us started on what we need to do immediately. So Sarah, the floor is yours.
Thank you, Teresa. It's hard to know just where to begin in assessing the changes that are being proposed, because they are so massive. In fact, the Biden administration's proposal is over 700 pages long, significantly longer than the proposal issued under the Trump administration and Assistant Secretary Betsy DeVos. My role here at Heritage is to essentially write, research, and advocate on a traditional textualist understanding of both the Constitution and statutory law, for which I was well prepared as I was senior counsel for civil rights in the Department of Education's Office for Civil Rights under Secretary Devos. And I was one of the attorneys there that was tasked with reviewing the 124,000 comments we received from stakeholders and the interested public, and went through the arduous notice and comment period in development of a rule that was released on Title IX in May of 2020. That rule did a few things, not the least of which was to clarify that sexual assault and sexual harassment were both discriminatory conduct under Title IX, both at the K through 12 level and at the secondary education level. We were recognizing a very problematic trend of sexual assault, particularly so in primary and secondary schools, that we clarified in the rule. We also clarified that religious institutions did not need to seek a religious exemption formally, but that if they were facing a discrimination complaint under Title IX, they could simply assert the religious exemption without any extra effort on their part whatsoever. We also instituted a number of due process protections, as I'm sure many of you are aware, including the ability to call witnesses, cross-examine witnesses for the accusing party, offer introductory evidence, and essentially choose whether or not the preponderance of the evidence or a clear and convincing standard was more appropriate based on the evidence at hand. It gave the sense of these Title IX investigations a bit more of a quasi-judicial feel, which was our goal, as these are obviously circumstances that transpire on college campuses. They are administrative in nature, but they have significant impact on the lives of both the accused and the accuser. And one of the many things that we did was to encourage reporting of these incidents to law enforcement where appropriate, so that there could be dual tracking of many of these individual claims. That was a rule that, again, was released on May of 2020 in the Federal Register, finally published. But what we've seen come out of this administration is significantly different. And there are quite a number of changes, not the least of which is that it allows Title IX complainants who have graduated or withdrawn from the university to still file against the university. It has also expanded the jurisdictional reach of Title IX, meaning that institutions are now required to apply their Title IX policies and procedures to sex-based harassment that occurs outside the United States, and now applies to study abroad programs in divergent nations. It eliminates the requirement of a live hearing in higher education for sexual assault and sexual harassment cases. It again establishes only the preponderance of the evidence as being the appropriate standard, the lower evidentiary standard in civil rights law, as opposed to a clear and convincing standard, which is more of an immediate scrutiny standard that is just one step below, beyond a reasonable doubt, but certainly more protective of the interests of both parties involved. It also expands the definition of sex discrimination to include sexual orientation and gender identity. It includes among those pregnancy characteristics or pregnancy status. And Doreen will talk a little bit about this, but that will fundamentally open the door to protection of abortion services on college campuses, making the same available to all complainants who, because they are pregnant, can now file and platform a sexual harassment claim simply because they aren't able to access abortion services. Among many other consequences of this rule, and you can see that there are quite a number of changes. It is an utter rollback of a rule that we finalized again in May of 2020, after having gone through 124,000 of these comments and following the arduous Administrative Procedure Act process. So we've yet to see any justification that passes muster from the Biden administration as to why they want to rewind the clock and reestablish Obama-era guidance as it was offered in these informal Dear Colleague letters back in 2014 as sort of a parting shot to the end of his administration. There are quite a number of implications for free speech as well. By expanding the definition of sexual harassment or sexual discrimination to include sexual orientation and gender identity, it sets up a de facto heckler's veto. Now this would platform claims of Title IX discrimination violations if, for example, a professor refuses to use a student's preferred pronouns against their sincerely held religious beliefs, for example. And we can see where the intersection of a public school professor is themselves religious in conviction and is bound to follow Title IX institutionally, but individually has religious objections to the use of preferred pronouns because of their belief on sexual and gender traditional orthodoxy. So the heckler's veto is always going to be a problem now under the Biden administration's new and proposed rule. And as sort of a final complication, there are two significant entanglements with this rule and two other federal civil rights regulations, not the least of which is Section 1557 of the Affordable Care Act, and that's the non-discrimination provision in any federally funded hospital or healthcare setting. And that would now, again, because the setting is relied upon in these Medicare funded or Medicaid receiving hospitals and facilities, the Affordable Care Act takes for its definition of sex discrimination the definition that we find in Title IX. It incorporates it by reference. There is parallel rulemaking transpiring right now on Section 1557, but a change of Title IX in education under this proposed rule is also going to have a significant impact within the sphere of healthcare. In addition to that, the Food and Nutrition Act and the USDA, which is one of the enforcers of Title IX, will also be impacted. And in fact, the USDA issued informal guidance itself approximately 2 months ago, indicating that it too would be expanding the definition of sex to include sexual orientation and gender identity, and that any individual institution federally funded and not complying would be subject to a complaint and would ultimately be subject to potentially losing their federal funding. So through school lunches and through healthcare, we see Title IX is not just K through 12, it's not just secondary education, it is also specifically school lunches, and it is also specifically the healthcare format. So again, when I say it's hard to summarize the expansive nature of a 700-page proposed regulation that this administration has offered, it has a multitude of applications in a multitude of settings, none of which are good, and almost all of which will run the clock, not only on women's progress and advancement, but on the protection of individuals, both in the higher education environment, as far as sexual harassment and assault are concerned, and in the K through 12 environment, when we're looking at the free speech rights of public education employees and teachers. That's a lot of information, but at this point, I'm going to turn it over to Doreen, who's going to dig down a little bit on the expansive definition now of sex and what the implications are specifically for gender identity.
Thanks, Sarah, and it's lovely to be with all of you today. We are really counting down on the clock right now for comments, which are due September 12th. And so we're hoping that this opportunity today will inspire everyone to get in there and make some comments and substantive comments that they've got to respond to. Just one more point by way of context. After the rule in 2020 was promulgated, the final rule in May, you might recall that there was a big decision among the Supreme Court, the Bostock decision. And as we know, this is the basis that basically the Biden administration is using as what they would say is the legitimacy, the Bostock reasoning, that to basically lay the foundation for their proposed changes to Title IX in regard to the definition of sex. Now, you probably know that there was nothing in the Supreme Court decision that actually gave them the legitimacy for that reasoning beyond the suggestion that there is something like transgender status and that sexual orientation in the employment context should not be a cause for hiring or firing employees. But we all know that the reasoning, which I think does probably take up at least 50 to 100 pages of the preamble, is trying to make the case based on the Bostock decision. We also know that this administration from day one, when Biden came in office, has an aggressive agenda to redefine all non-discrimination laws based on sex to include gender identity and sexual orientation. Day one, his executive orders, which were followed by the new notice of interpretation. And then, of course, there are many state interests that they've placed in the courts that also establish their policy. So what we have by the way of a proposed rule is really just the culmination of the aggressive agenda that they had from the very beginning. I would have to say that if you read the campaign website of the Joe Biden running for president, none of us should be surprised, and frankly, is only the fulfillment of promises. So you have to give them credit for that. That doesn't make it legitimate, and it definitely doesn't make it something that we want to see enshrined in federal law. But to this point, as Sarah mentioned, I see that what happened with the sexual assault rule, they're using that as pretext. Certainly they don't like what Devos did and they want to revise that, but they're really using it as pretext to redefine in a very insidious way the scope of what Title IX encompasses in the meaning of on the basis of sex. So just to make that very clear, they say that discrimination on the basis of sex includes discrimination on the basis of sex stereotypes, sex characteristics, pregnancy or related conditions, sexual orientation, and gender identity. There's no recognition that sex is actually sex, like what we understand biologically. In fact, they specifically choose not to define sex. Frankly, that would be something that would have been nice under the Title IX rule in 2020, so that we would be in a different position on that, but that didn't happen. And we see the traps that laid the snares for today. Beyond the scope, there's an application of this that makes very clear about what they mean in terms of recognizing gender identity as a category. It says that adopting a policy or engaging in a practice that prevents a person from participating in an education program or activity consistent with their gender identity, that means adopting a policy that would prevent that, subjects a person to more than de minimis harm on the basis of sex. Now, this standard that's set of more than de minimis harm really doesn't have any further explanation. But what it does suggest is that anytime a person would be treated not like what they believe they are or want to be declared that they are by way of gender, would become a discriminatory act that would be a claim for sexual harassment or discrimination. Right there opens the Pandora's box of the problems that we foresee this creating, which was mentioned earlier about the kinds of complaints, how you adjudicate those complaints, what that means in any level of education in terms of the imposition of gender identity ideology, and what really the future for women that women have under Title IX. Now, I got started in this whole debate about 5 years ago when we were seeing what was happening in women's sports, when we had biological men that were competing against women at the high school level, then the college level. Concerned Women for America has filed 3 civil rights complaints against universities who allowed for biological men to participate and compete against women in track, in cross country, and in swimming. One of those was successfully resolved under the Trump administration. My hat tip to Sarah Perry, who made that happen, against the Franklin Pierce University, whose athlete known as Cece Telfer won the first national title in an NCAA competition. What was decided at that point by way of resolution with the university was that they had to discontinue their policy of allowing for males to compete on their teams and in sports, but it basically stopped there. And then we know what happened in November of 2020. We have filed a complaint against the University of Pennsylvania as of March based on the situation with Leah Thomas, and really focused mostly on the sexual harassment, intimidation, and hostile environment that was created in the locker rooms, on the teams, that we know as a result of accounts provided anonymously from the swimmers themselves. Unfortunately, that hasn't been moved ahead. Certainly, we don't expect that under this administration, but also not yet in any way in the courts. We do have other cases in court, though, across the country, in fact, multiple cases, whether it deals with sports competition or also what's happening in schools today regarding the dangers of gender ideology. I'll just read a few recent headlines about different cases. Parents sue Wisconsin school district over gender transition policy. Emails show Pennsylvania school counselor told teacher to hide students' gender transition from parents. Mm-hmm. Maryland school district bars staff for telling parents about gender transitions. Iowa school district sued for providing gender transition plans to students without parental consent. So we see here the setup of the obvious conflict that's happening, the cases, and frankly, none of this is hypothetical, as we know, the crushing and heartbreaking cases happening right now with students and their parents, with schools trying to interfere with the well-being of these children, immediately providing gender-affirming care that somehow has to allow them to have, changing closets so they can put on their new clothes, that they're called different names at school, they're addressed by their pronouns, and doing this with gender support plans that specifically only require student consent, not the parents. And the situations right now are heartbreaking. Frankly, we're going to have more of these cases resolved in the coming months. But this administration and what it wants to do in this Title IX law could basically upend any of those cases and straitjacket any state from having policies that would help to protect students from this kind of ideology. We know that in and of itself, the opportunity for a child to go in and start socially transitioning in schools leads them down a pathway of chemical and surgical treatment that only becomes lifelong devastation in terms of their bodies and their minds. And so we want to be able to prevent this by opposing this rule, making it very clear about the dangers behind this. I would say too that one of the flaws in this rule, not to mention the many unanswered questions that this raises, and frankly, I've just finished, doing a first draft of our comment. I've got 94 questions in like 10 pages of the kinds of things that this administration hasn't chosen to recognize in terms of the chaos this will create and what they really mean by these terms. They use terms in this rule that have never been used in Title IX before. They use the term gender identity, gender nonconforming, queer, bisexual, heteros, gay, all these other terms that have no definition, and frankly, what gender identity would even mean, that would require a standard of more than de minimis harm if you didn't treat it accordingly, is really left for anyone to interpret on their own, which is a reason that I think one of our main plays against this is to talk about how arbitrary and capricious the result of this rule will be in any attempt to implement it in any school across the country at any level of education. They also suggest, and again, I see this is really kind of the fatal flaw of their own reasoning, that athletics is really off the table here. They're going to come through with an additional rule. They're not trying to make any changes to its application to athletics because they will come up with criteria, if any, that need to be recommended or I guess required for making decisions about whether males or females would participate on which athletic teams. Well, let's realize that the whole reason that Title IX came into being to start out with was for women to have scholarships, educational opportunities, and athletic opportunities that were equal in kind to men. So how they can just leave that off the table and legitimize a rule, which then by its current way of being worded would automatically apply in application. Otherwise, students would be considered being treated with more than de minimis harm. How do they leave that off the table? Which is, I think, a reason that all of us are interpreting this as not being irrelevant for athletics as much as they want to suggest it is. I think they're reading the polls. I think they understand that the American people don't agree that having males and competing in women's sports isn't fair, and that they want to, they're basically really liable in an election year to have that become a suggested policy. So we're not leaving that off the table. We think that in many ways already the statement of interest that this administration placed in a court case in West Virginia challenging their state policy restricting female athletics to females already states their policy. We already know what they mean. They already have a notice of interpretation that's forcing an interpretation on schools. And so all of these things are relevant. The other thing that I want to mention, and this really does have to do with a very central question about the rule as it relates to defining federal financial assistance. We all know that we have all interpreted that this Title IX has been limited in some way to all universities, of course, because they receive federal financial assistance as a result of student loans and grants. But one of the things that's happened just recently in the trend in the courts is that as it pertains to schools and especially religious schools, federal financial assistance has been interpreted under Title IX as including tax exempt status. I think there's a very clear question that is going to have to be raised here about whether or not tax exempt status of any institution or organization, educational program or activity would constitute federal financial assistance in a way that would have these Title IX implications imposed on them in ways that haven't happened in the past. So that's one of our central questions. The other one that, as it relates to termination of pregnancy, the question about pregnancy and related conditions, the obligations of universities now, we know that this administration wants to use any avenue to try to define abortion into their policies around sex discrimination, and certainly we'll be doing this in Title IX. What are the obligations of universities in this case? What does that mean? Do they have to provide access to, facilitate awareness of, prevent any pro-life messages on campuses, because doing so otherwise would be harassing women who might be considering abortions? What does this mean for the universities today? I think that's a serious issue. The other one that does relate more in the elementary secondary category, but is the term of parental status and acting in loco parentis. For the first time, they include a definition of parental status that includes in loco parentis. We understand that in cases of sexual assault or child abuse, we would hope that schools would be aware and trying to protect students. But this is, again, in the age of gender identity, when they're hiding realities from parents, because doing so, not participating in the gender beliefs of a child would be somehow discriminating against them sexually or possibly harassing them. Will this give them greater leverage to act in these cases, as the headlines that I mentioned to you do implicate? So there are so many different issues here. As Sarah said, it's really, it really could fill volumes in terms of, I think, the comments that we have to create to consider. And I would just stop there so I don't take any more time so we can open it for questions.
Yes, Doreen, thank you so much for that comprehensive reaction. I do want to just step back and recap. I think Sarah was talking about the domino effect of Title IX. It has implications well beyond just the campus kangaroo courts, into cafeteria, into healthcare. Just shows you give these people an inch, they take a mile, this relentless toying with definitions. That said, let's not get too depressed because we know that this is a top-down effort. The American public has never expressed any support of any of this gender ideology or of redefinition of sex in this manner. And we do have, Sarah, I'll let you comment on this after I go through my notes, a recent Supreme Court case with West Virginia suing the Environmental Protection Agency, where the court found that the agency, in making major policy determinations, had overreached its lawful authority. So administrative overreach. And I think that is going to be an important case in the Title IX area. And this is nothing if not administrative overreach and redefining sex in ways unimaginable to those who supported this legislation in the 1970s and even later. So this does not have support from the public, and perhaps more importantly, doesn't have the support from the courts. And one additional note on that is that even in the area of due process erosion and sexual assault, a lot of what the agencies have done have flouted court opinions, including from the Supreme Court, which wanted to rein in Title IX to keep it to educational access. The most recent being the Devos versus Monroe case, which the agencies have come up with flimsy excuses to ignore that opinion. So a showdown is coming, and we need to take comfort in the fact that the American public is not with these gender ideologues, and the courts don't appear to be with them either. So source of hope. One, Doreen, clearly the tax exempt status question is a way to go after religious institutions. They correctly see religion as a stumbling block for their totalitarianism. Thank you for calling that to our attention. I wanted to clarify one thing. You said that you brought a complaint against the Franklin Pierce University, and that was resolved favorably to remove men competing with women. However, your complaint against the University of Pennsylvania is stagnating because it is now with the Biden administration as opposed to the Trump administration. So I wanted to see that I had understood that, and also throw out for both of you that it is true we are now seeing a hostile environment toward women. One could also say we are seeing hostile environment toward people of European descent, what is called white privilege. This veers into racial discrimination. But I want to sound a note of caution. I don't know if you guys are with me on this, that part of the problem here is this ever expanding nebulous, words say what I say they mean, and nothing more, nothing less, like the Queen of Hearts and Alice in Wonderland, that hostile environment, which got us where we are. Now, Doreen, you are using hostile environment as a sword. You're fighting fire with fire. I'm a little uncomfortable with that. I'm not opposed to that, but I hope you understand the reservation. It may be what we have to do, but can you understand the discomfort I have? Can you address that? Can you confirm that that's what you're doing?
Well, in the case of Leah Thomas being having access to changing areas, locker rooms, having the university tell them that the students tell them that they could not speak out about their discomfort, that they didn't have any voice or capacity as females, as women. I'm not going to stand aside to not call that a hostile environment. And that was our point.
Let me offer also a few points that I've seen sort of come up in the chat. Joe had mentioned what happens when females are presented with biological males who identify as being female, and they themselves are actually suffering a Title IX discrimination. I've actually brought this up. It's in the legal memo that I've attached in the chat, and it's extensive. It's about 18 pages long, exceptionally footnoted, but ultimately the conclusion is these are the kinds of things that the Department of Education has failed to consider. When you are faced with an individual who identifies as a female with a biological female, both desiring access to the same private space that the regulations of Title IX indicate ought to be separate due to inherent biology, you've got competing claims. How those are going to be resolved by this administration is anyone's guess. We understand by the politicking, of course, where we think it's going to go, but practically speaking, administratively speaking, and legally speaking, this sets up essentially an arbitrary and capricious argument that the rulemaking itself was always designed to achieve an ultimate political outcome, but wasn't actually about solving a problem. And that is what the Administrative Procedure Act wants done. Follow this process in order to solve a problem about the ambiguity currently existing in federal law. The ambiguity for us was sexual assault and sexual harassment. Did those constitute significant enough, pervasive enough discrimination to warrant a Title IX complaint? And our rulemaking and the input from stakeholders indicated that yes, indeed it was. We clarified that ambiguity. In this instance, there is no ambiguity that is needed to be clarified. What they're essentially doing, again, is rolling back the clock. So you will now have competing claims, and I actually address a number of considerations that this department has not taken into account, including the cost of litigation that these individuals, school districts, schools, universities, colleges will now be faced with when they have competing claims of Title IX violations at the same time. I also wanted to mention, because I saw someone did bring up in what format the tax exempt status was considered to be a benefit and therefore subjecting a religious institution to Title IX. That was actually a federal district court case that just came out very close to me in the District of Maryland. I know very well Concordia Prep, which used to be Baltimore Lutheran. That was the case at issue, and essentially they were given a determination that they were subject to Title IX, regardless of their underlying religious status, but because they benefited from the tax exemption that the IRS had given them as a religious institution, they too were subject, regardless of the fact they had a statutory religious exemption. It is the first opinion of its kind. I'm hoping it is very quickly reversed on appeal to the Fourth Circuit, but now we have bad federal precedent saying, regardless of any statutory religious exemption, your tax exemption is now good enough to subject you to Title IX in the end.
I'm sorry, did you say that's a federal trial court decision?
Yes, it's the U.S. District Court for the District of Maryland.
Okay, well.
So I would just add on to that, there was a second opinion in the same week in California, Ninth Circuit, or Federal District Court in California on the same, with the same reasoning. They used, so we have two now on the books, opposite coasts, and that raises an entirely different set of issues. As never has been before.
This is on the question of tax exemption for religious schools and subjecting them to Title IX, both these opinions, the Ninth Circuit and the Maryland one.
And it wasn't Ninth Circuit, it was a federal court. It was a district level in California. I misspoke on that. But yes, they were both they were both religious schools. They both said on the basis of their tax exempt status, they would come under the definition of federal financial assistance.
Okay. I can't imagine that that's going to go further. It sounds like you got a hack trial judge, not to minimize the importance, but I just can't imagine, because the religious institutions will come out like gangbusters. That's so threatening to them that tax exemption should be considered federal assistance. Sarah, I just wanted to commend you for pointing out that this creates an access to education issue for the biological females suffering the presence. I've made that point with respect to sexual encounters where both parties are under the influence of alcohol. Well, technically neither one could consent and both could lodge accusations of sexual assault against the other if they're both under the influence, but typically we only see these accusations going one way. Also, Sarah, with respect to problem solving versus it almost seems like problem creating. We've got agents of chaos who are creating these problems on the ground. It's the antithesis of problem solving and clarification, which brings us, I always go back to the question of personnel, both in the schools and in the federal bureaucracy. We have some bad apples operating as unqualified, unaccountable policy makers. I mean, this is lawlessness. Call them commissars or apparatchiks. They're not operating with lawful authority, and yet they're on the ground in the position to redefine, or they're in federal agencies behind closed doors, redefining and thereby imposing these left-wing objectives on American families and on American students. So let me stop there. If you have, I have one other sort of umbrella comment that's related to that, but it's something I've been wanting to ask, but I'll stop and see, does anybody want to respond to what I said? And let me check here on the chat. I'm a woman and many lesbians oppose the dismantling. Yes, so one comment in the chat is that I think traditional feminists and even in the homosexual community are against what is happening with women's athletics. This is a sort of a question that hasn't been brought up, but I'd like to get your feedback. I don't know if you know Samantha Harris, who is an attorney in private practice with many Title IX cases, who reported that after the Devos rule took effect, schools were on their own deciding to prosecute or go after sexual misconduct pursuant to their own student conduct codes. This was a way of avoiding the due process requirements of the Devos rule with more expansive definitions of misconduct in their own conduct codes. This raises the issue of whether Title IX was ever needed in this area. Couldn't all of this misconduct be handled as either a criminal matter, and thank you, Sarah, for encouraging schools to report these matters to the authorities, or as a matter of student misconduct already addressed by student misconduct codes? Didn't Title IX basically create a man-hating militant feminist apparatus in the schools that was a total transfer of power to these bad apples, giving them a bite at the apple to advance their ideology, when in fact these problems could always have been handled by the school's conduct code? Now, I realize there's cold comfort to some extent, because who's in charge of enforcing the student conduct code? Well, according to Samantha Harris, these ideologues who want to deprive people of due process. But I ask that because it does put front and center, if they are neglecting, not using the Title IX track. I don't know, Sarah, if you're familiar with this, but using their own disciplinary track, why did we have Title IX in the first place?
That would require going back through the history, of course, but there's always a hook of federal funding, right? So they are subject, once they are subject to federal civil rights law anyway, and all federally funded, whether directly or indirectly, all federally funded institutions are subject to the promulgation of federal civil rights law. So they may have their own codes of conduct. Those are always ancillary to the superseding and preempting federal civil rights law in the first place. And where we're also going to get into, without getting too legal, questions of preemption is the 16 states that have laws already on the books that have been democratically enacted that protect biological female in athletics. For example, I give you Florida. Now, when they are faced with the conflict between following their own democratically enacted laws and what Title IX may look like going into the future, precisely which interpretation passes. The Supreme Court has indicated it has a preference against preemption. It is a states' rights issue. So we're going to see so much litigation on this going forward. The costs to the judicial system are going to be usurious, and the cost to universities and colleges who are desperate to comply with all appropriate laws are also not something that's been dutifully considered.
Right, they're in the crosshairs. So
I would just say that I think that the rule itself specifies that it preempts state law in most every case here. So we're setting up through this actual rule, if it's final, that it would be obvious what Florida would have to do, which is the universities. This has actually been a discussion in the Atlantic Journal-Constitution, had an interesting article on the issue of abortion, specifically what this requires with termination of pregnancy and how it's going to set up schools if you have a state like Georgia that has, a heartbeat law that, or a state that's protecting against, abortions, that if schools would find out if they would be allowing for students to go across state lines and then give them special exemptions for tests and so forth, would they be held liable under the law of Georgia's law? I mean, you can see how they're thinking, what you're setting up here on so many different levels. And to the point of whether or not we needed Title IX to start out with to begin with. Well, I think that organizations like Concerned Women for America, which were founded during the fight of the ERA, were always questioning the need for that, where it would go. And I think we see the fruit of probably that prophecy playing out now in terms of the way that activism around these issues would go. But whoever thought that liberal women who were championing the ERA would actually turn their backs on their own actual status as female. We are among the organizations that worked in hands with the leftists who are called, TERFs, because they actually believe that women are women. But so many women in the liberal category, and certainly all the Democrats who've voted for the Equality Act, don't care about what it means to be a woman anymore. And in fact, they're actually saying that men can get pregnant, and I saw some of that in the chat as well. And so we're just, it's literally dystopian what we're facing right now in this whole area of law. And frankly, the chaos. I think I think that this rule, my hope and prayer, frankly, is that it falls under its own weight. And as we've said, it is no clarification of law. It is a chaotic reinterpretation that has no bounds. In fact, I'll point out, since it hasn't been mentioned, that the scope that was defined there says including, but is not limited to. And so the administration is making very clear in their rule that they're not excluding any potential other categories of potential claims that could be potentially related to anything related to sex. And so therefore, we have no way of interpreting what this really means, and no one knows what they should actually do.
Yeah,
and so I think
that is part of the reason that I do think a legal challenge to this will ultimately be successful. And Doreen, you're right. In fact, the 700 pages of proposed regulations do say preemption. I'm going to tell you, you can't discharge constitutional principle by simply saying you're discharging constitutional principle. So, and if we've learned anything in this past Supreme Court term, between the CDC eviction moratorium, the OSH federal vaccine mandate, and the EPA's attempt to squeeze through a emissions cap, that this particular court, if it finally gets to this point, is going to determine, listen, Congress had the opportunity for 50 years to clarify things like gender identity and did not. It's had multiple opportunities. Title IX was amended in 1997. They have not chosen this action. Leave that presumption to the actual body that enacted the law in the first place. I see nothing about this law that is going to pass legal muster. I know I sound hopelessly optimistic, but I truly do believe it is one of the greatest overreaches we've seen from this administration on its overhaul of federal law.
Yeah, absolutely. And that's a great note of hope, as we wind up here. But I do want to emphasize that activism, action by citizens in the states for the public comment remains critically important, because the courts will take notice of, for example, the proliferation of due process laws or laws recognizing biological differences. Courts, in their opinions, take notice of that action as how public opinion, as how undemocratic and unlawful agency action can be. So yes, we're very hopeful, since I agree with you, Sarah. I think the courts are going to ultimately reject this. It can do a lot of damage in the meantime, I want to invite, as we get to the end of the hour, for you to make final remarks. I'll just say, in reviewing the Biden proposal, one thing that is most maddening is the seemingly innocuous language that they are merely clarifying and merely addressing the scope, or merely extending as they are imposing the most radical redefinitions on the American public. So it's infuriating to see that bureaucratic happy talk as they are basically engaging in lawlessness. But Sarah and Doreen, we'll start with Sarah. Do you have any final words for our listeners?
I would say be active and comment. There are 11 days left in the comment period. I've included a link, not only to the legal memo that you are happy to cut and paste from. I welcome you to use whatever portions are helpful in creating your own comments. Encourage other people to do it. So far, as of today, there are 139,000 comments that have been received, which is more than we received under the Trump administration. That's encouraging. A lot of people are very concerned about this. I've also included a link to heritageaction.com, which has a toolkit to also help you create, develop, and submit comments as well. And I think there's reason to be encouraged. It may be a long process, but they are clearly over their skis on this. And we're encouraged. There were so many participants on this call who are likewise concerned about this.
Yeah, the overreach is going to produce a pushback equal in intensity and scope, is the hope. Doreen, do you have closing comments?
Agreed with going over their skis, and I hope it's a really hard face plant. But likewise, just I put in there concernwomen.org or any of our materials if they're helpful to anybody. There's a little video up there too that we're circulating. I would make one other point here, just in terms of the rulemaking process and their obligations. Certainly, they're required to respond to any substantive comments. Anything you can do to put sand in the gears with questions, with challenges. They have to have regulatory impact analyses for its impact on small businesses. They're not calculating costs. Sarah mentioned the legal costs, the untold conflicts that this is going to create. We're raising all of those issues. One of the best things we can do is just to make this so hard that they are literally crushed by the weight of their incapacity to actually make this make sense at all and have any legitimacy at all. So appreciate everyone's time and attention today, and it's been a pleasure to be with you.
Yes, thank you so much for this active and robust discussion. For those wanting the Federal Register link, Chance has put it in the chat. We will also, the National Association of Scholars, follow up with this to our members and include that link as well. Sarah and Doreen, it's been a real joy conversing with you. I hope we have occasion with a better cause, better impetus for a discussion in the future. So thank you. Have a great afternoon, a good Labor Day weekend, and we'll be in touch. Okay.
Thank you.
All right.